20 years, that's how long we played the roles. Wife, mother, partner, provider, until it all changed.
We honestly didn't see it coming. Then again, maybe we did. But divorce didn't break us, it rebirthed us.
Now we're navigating motherhood, healing, dating,
friendships, religion, and sharing how we started over.
This is Uncharted Phases, a podcast for anyone starting over and owning every step.
Welcome back, everybody. This is Raechal, and I've got Melissa here with me. It's another Uncharted Phases episode, and we are talking episode 6, which is DIY or Lawyer Up, Split Happens. So we are joined today. I am beyond excited by having Gene Sollows with us. And Gene is an attorney, and he is the owner of Sollow Family Practice. So we're excited. What we want to do today, Gene, is kind of just talk overall about divorce, how to get started when you decide you're going to get a divorce, or when someone decides it for you. So we've got some good questions for you. Thanks for joining us today.
Yeah, happy to be here.
We're happy to have you.
Very. Okay, so Melissa and I both did our divorces a little bit differently. So we kind of have separate questions that we went through with both our divorces, but we want to kind of start with the basics. One of our big things that we try to help our audience with is the whole phrase, start here. So when you're unexpectedly served with divorce papers, what would be, and then I'm going to actually do a follow-up question of when you're thinking about divorce. So the first is going to be when you're unexpectedly served with divorce papers, where do you start? What do you do? Like, what's the first thing you should do?
Well, when you're served, and it sounds like you've got two different questions. One, if you're the initiator and you're filing the case, and we call that the petitioner. And then if you are being served, then you're the respondent. Okay, so your first question was as if you were the respondent, you've been served. Some man or woman came to your house or to your business and handed you papers, and they're very thick and very confusing. And attached to the top paper is going to be the petition for divorce. And that's what we call the pleading, which is the legal document that starts the case. And it's a lawsuit. A divorce is a lawsuit. You've been sued. And so the top paper that you're served with is called a citation. And that's the notice that says, hey, you've been sued. You have 20 days. And then to the next Monday after that to file an answer. And if you don't, a default judgment might be taken against you. And so it's advising you that, hey, you need to do something. And that should be your trigger to probably call an attorney, mainly because if your spouse is serving you with a petition, they're not asking you to sign a waiver of service to do it in an agreeable way. They're saying, no, we're going to go ahead and start it as this contested lawsuit, and we're serving you. And you probably weren't just served in that instance with just the petition, which is the thing that starts the case. You were probably also served, as you mentioned, with a temporary restraining order and possibly an order setting a hearing. So you're served with two things. And so it's not only, hey, you have to file an answer, but, oh, by the way, there's this hearing coming up, and here's all these things you can't do between now and the hearing. So it's a lot. And if you're not expecting it, it's mind-blowing and very difficult, especially coming from, somebody that you loved and trusted for so long.
Yeah. So let's talk for a minute about being the respondent, and then we can talk, like Melissa will have questions on being the petitioner, but being the respondent, I didn't serve my ex-spouse with a TRO, but my friend was served with divorce papers and a TRO. Why is a TRO so important? Because you hear the word restraining order and you think, I didn't hit him. I wanted to.
That sounds right.
I didn't threaten him. I wanted to, but why am I getting this TRO?
Sure. Well, and some of this is varies from county to county. So I primarily practice in Tarrant County, but in many of the other counties in North Texas, they have these automatic orders that go into effect in every case called standing orders. So if you have listeners in Dallas or Denton or Collin County, for example, they have these standing orders that kind of take the place of the temporary restraining order. And it basically says, don't do anything crazy. Don't, throw their clothes on the front porch and light them on fire. Don't, don't drain all the money out of the bank accounts. Don't take the children to another country. Just the crazy bad behavior stuff. And so those automatic orders called standing orders happen in every case in, for example, Dallas and Denton and Collin County. But in Tarrant County, we don't have standing orders. And so if the petitioner who files the case needs some immediate order just to kind of maintain the status quo, they request a temporary restraining order, which is different from what you alluded to, which is a protective order. So a protective order
I thought they were the same thing.
That's very common. So a protective order is a very serious, almost a criminal type proceeding where somebody is prevented from coming around you. And it's either because there's been family violence or criminal level of stalking, let's say. And that would be sort of your celebrity, stalker types, get a protective order against them. That's sort of the horrible family violence, cases you might have heard of. That still happen, by the way. That's protective order land. But for a regular divorce where those sort of things aren't happening, there's still, like in Tarrant County, a temporary restraining order, and it's going to restrain you as the respondent from a variety of things. But generally, it's don't do anything crazy. In extraordinary cases, it might say you can't have access to the children, or you can't come back to the house, or things like that. And a lot of people take it that way as if that's what it means. But if it doesn't specifically say that, it doesn't do that. And so sometimes people kind of overreact to the TRO, and they completely, back off.
Well, it sounds terrifying. And
sure. Yeah. And even the petition that starts the case, the thing that's attached to the citation that you're served with, there's some salty language in that too sometimes about that if you're not an attorney, and it's kind of offensive, like in the request for relief at the end of it, the legal jargon is it's called a prayer for relief, and people get offended, like why are they praying in this divorce case? It's an odd use of the word, but there's just a lot of language in there that for regular folks, it's just it's weird and offensive,
So you get these papers, like what's your first step? Like how do you even find a lawyer? So I did all of my divorce by myself. So I've never talked to a lawyer. I have no idea where I would even find a lawyer. Would I be looking up on the internet? I need a divorce lawyer. What type of lawyer am I looking for?
Yeah. So I practice in the area of family law, and which is a little confusing because sometimes people think of family law as being sort of lawyers who represent families, and it's really not that. When we say family law, we mean things that happen in family court.
Okay.
And family court matters would be things like child custody cases, divorce cases, because there's, obviously there could be a child custody case with people that aren't married, right? Yeah. Adoptions and protective orders. Sometimes it's a case where it's about a child, but maybe the parties are more than just the parents. Maybe there's a grandparent involved, or somebody who's been acting like a parent. And then also family law includes cases brought by the Attorney General, who creates and enforces child support obligations for lots of folks in Texas. And so all those things are kind of under the umbrella of family law. So you would want to look for a family attorney.
Okay.
And then as far as the source of, where you might go, what you're doing now is a great example of what I think people should do, which is, talk to their friends and people who had an actual experience with somebody that was hopefully not negative and who were able to accomplish something. So I would say a personal referral is the best. But if you really have nowhere to start, or you want to talk to 2 or 3 people, I think these days online is just as good as any. But I can suggest to you that you want somebody that's local. That's super important in family law. So, for example,
in the county you're living in.
Yeah, and I live and practice in Keller, but I'm primarily in Tarrant County. Now, I also go to Denton and Dallas. Rarely I'll go to Collin County, or sometimes Parker County or Johnson County, that sort of thing. But for the most part, I'm here. And there's a good reason for that, which is that like in Tarrant County, for example, there's 6 family law judges, okay? And each one of them has a helper judge called an associate judge. So there's So that's 12 people right there, and then there's two child protective courts that are there. And then there's 3 courts that are just for the attorney general. And this is all in one building. So there's 17 judges
Ooh.
just in Tarrant County just to deal with the people that, can't figure out how to make the relationship work with the people that they married or had babies with, which is pretty shocking when you think about it, that there's this giant apparatus, just for the people in Tarrant County, and there's even more of a structure in bigger counties like in Dallas or San Antonio or Houston. So, you want somebody that's local because you want somebody that knows the local practices, and because it's different from county to county and it's different from judge to judge, and you need to know your audience. And so if somebody calls me, for example, and has a case, which this happens, like, hey, I need you to represent me in Austin, I refer them out because I don't want to do them a disservice by, not knowing what I don't know about the local courts there.
I've never thought about that before.
Yeah.
I had no idea.
So what is your recommendation? Okay, so I read on a neighborhood Facebook page actually the other day of somebody that said, I'm getting a divorce. What's my first step? And somebody actually commented and said, make an appointment with the top 15 lawyers in your county and meet with all of them. And then that way it conflicts out. It conflicts him out. And then another person said, if that is what you want to spend your emotional energy on, I think that's a waste. But, I would recommend maybe meeting with 2 or 3 and keeping the focus about you, not who you don't want him to see or her to see. What's your thought process on that?
Well, I agree with the second person 100%. And frankly, that sort of story or that kind of meme about that is something that's been a thing, and it's been in TV and movies and that sort of thing where people allegedly did that. And I suppose if you were super motivated and had an army of people devoted to,
who has the energy for that?
I suppose that could be done. But the attorneys, whenever I talk to somebody, one of the first questions I ask is, well, who's the other party? Because we have to do a conflict check and make sure I haven't talked to them before. And I'll ask, how many people have you talked to? And, if I get the sense that I'm, being, used for that purpose, I'm going to probably end the call, because it's not fair it's a waste of my time and their time. And so I don't think that's proper.
Good. Yeah.
So, but I've heard of that, but I've never had it happen to me. But if I got the sense that somebody was just literally, calling 40 or 50 people for that purpose, I would be. And then there's a legal question about when does the conflict of interest get created? Like if somebody just says hello to me, I haven't, there's no attorney-client relationship and there's no privileged conversation. Like we're just talking, right? So anybody that is hearing this, we don't have an attorney-client relationship, and that's okay. But once we start talking about the case and I'm giving you legal advice, then I am.
Yeah. Okay. So here's my question for you. If somebody like me who did my own divorce, I just really went into it completely naively. I wouldn't know if I was like, I need a consult. Are those free? Do they cost? What comes in a consult with a lawyer? Yeah.
So I think there's a lot of variety there. So I do a lot of mine on the phone, although I will say that's relatively recent. Pre-COVID, most of my appointments were in person, which is fine. And I still do them. But I would say for the most part, people are more and more comfortable now with a phone consult. Occasionally I'll do a Zoom one too, but if they want to, kick the tires a little bit and, see who I am or whatever. But yeah, so that's the, usually the method. And I think for most people, the lawyer's going to need at least a half hour to just talk to you and understand what's going on. But I will tell you that in more complicated cases where there's a lot of property involved or there's complicated child issues, it may need, 2 meetings or maybe 1 long meeting just for me to assess, what can I do for this person? What would be a fair estimate of a retainer, setting the fee. And so I would say for me, I certainly don't mind doing a half hour phone consult for free. That's perfectly fine. And usually, like for somebody like you, for example, you know, um, some people never have an occasion to call me because they've worked it out, and they're
Yeah.
just, it's for them, it's really more about just executing the paperwork and doing the legal
Yeah.
steps, which it sounds like kind of what it was for you. And so I don't see those folks because they don't need me,
Right.
and that's fine. And I've heard there are people like you that exist, but it's kind of the unicorn.
I'm
If
not
you
one of
are,
them.
yeah, but it's the old expression, when you're a hammer, everything's a nail, right? So it's
Yeah.
I'm the hammer in that way. So it kind of it's nice to know that people can work it out,
Yeah.
without having to get ugly about it.
Yeah. Well, and there's a lot that I think I missed the boat in because I was so focused on just trying to do something. I had no idea what I was doing. Like when I had to write a divorce decree, I'm like, I don't even know what that is. I don't know what it means. I was literally like
Sure.
Googling, like, is there any sort of like if you just need help with certain things, is that something someone in your office could help with for a fee? Or is it just kind of like, if you don't use us all the way, then we don't offer those
Yeah,
type of things?
so there are attorneys that do what's called limited scope representation, where they'll do some of the elements, like maybe they'll write up the final decree, or maybe they'll arrange for filing and for service, because personal service is sometimes tricky for people. But I would say, and there's forms that are approved by the state for people to use. They're kind of a checkbox
Yeah.
type thing, and that might have been what you used, and form fillable, PDF type stuff, and that's how it's done. But I would say that for most people, if they need somebody to kind of look it over or review stuff, that shouldn't be a bank breaking thing. And oftentimes, what'll happen is I don't get the call on that sort of stuff from the person filing. I get it from the other person, like who says, hey, my spouse filed the case and gave me this waiver of service to sign, and wants me to sign this final decree. What should I do?
What do you think? Yeah.
And so there I'm consulting with them, and I'm talking to them about what it means, and whether they could do it or not. And that's usually just a few hours of my time at the most.
Okay. And it's just like an hourly cost type of a deal if someone needed help.
Yeah. So I would say most family lawyers in that are litigators, which I am. We charge by the hour, and we get a retainer, which is a deposit. And we bill against that for our time on an hourly rate, and our paralegals are billed out at a rate too. And then that's called a retainer. And then you get a bill, and it says, oh, well, we started out at, whatever the retainer was, and we've done this much work this month, and here's how much you have left.
Okay.
And some firms will then say, hey, we want you to then reload the retainer back up to where you started, so that they'll bill you for that amount.
Okay.
And others will just kind of let the retainer go, and then after the retainer's out, they'll just send you a bill for anything that's over. There's different practices on that. There's different practices on what they charge for, or if they charge for, copies and postage and faxes and the nickel and dime stuff.
Okay.
There's different ways that's handled. I would say, most anything that is not purely consultation or reviewing somebody else's stuff is probably going to be an hourly thing. I rarely do flat fee type stuff because you
don't know how long it's going to take.
Yeah. And frankly, somebody probably doesn't get treated fairly in that arrangement, I would say.
Yeah. Okay.
Well,
either the lawyer or the client.
Well, yeah, exactly. Well, that was going to be my follow-up is, so what happens if then everything gets filed, things are great between you guys, and then it goes south, and things that you missed or didn't overlook, or think like, maybe it says 50-50 on health insurance, 50-50 copays, but you have this verbal conversation and he's like, things are not great for you right now. I'll go ahead and pay 100% of the copays for now. And it's verbal conversation. And then, he is like, oh, hey, a year later. And by the way, you owe me $2,000 for 50% of, because it's in the decree. And so what happens if I've written my own decree, I missed things, and then I'm like... Are
you telling him my life story right now?
Hey, I'm staying in hypothetical here.
Yeah.
Can I...
The names are being changed here for...
Susie,
right.
Can I then take you my decree and be like, did I
Can
write
we
this wrong?
rewrite this
Did
now?
I do this wrong? Yeah. Like, can you
Sure.
do
Well,
that?
that's a reason why you might want to, have it, drafted by somebody
Yeah.
so that you get it done right the first
Yeah.
time, but I can tell you that those sort of gotcha moments, are painful. And so if you're going to make that kind of, agreement, and so in your hypothetical, you were speaking as though the divorce was already over. And then
Yes.
after the divorce,
Yes.
there's these kind of
Because you're
handshake
playing
arrangements
nice
that are
with each
made.
other. Yes.
Sure. Yeah. So I would say if you're going to do that, then it should be in writing. And there's a lot of co-parenting apps that are portals
Yeah.
that are used for this purpose. And there's several of them that are free, or they'll have like an add-on fee for certain features. But those are often used for that, one of those purposes, not just to talk about your children or whatever, but also
Documenting agreements.
to memorialize that, hey, we're switching these weekends, or
Yeah.
okay, I'm going to pay for the counseling because you paid for the braces, or
Yes.
whatever the arrangement is. Okay. But it should be documented. And I would say if you've documented that, the judge is going to protect you on that later. So if he tried to, in that hypothetical, file some enforcement against you because, she didn't
Yes.
reimburse me the money, well, then you would have that. And I think the judge would probably, say,
Yeah.
bye-bye.
Okay.
Sorry, I would
No,
just say
fine.
that the main thing to keep in mind is, like, your hypothetical was after the decree was
Yes.
entered, right? But a lot of times this happens also during the case. And what I would suggest there is that you want to be thoughtful in the decree that it's handled all the things that could or might happen, and that it reflects the reality, right? So that the order and reality are as lined up as possible.
Mhm.
I mean, things change, right? I mean, people change jobs or they get remarried,
Yes.
or whatever, but you want that order to match reality. And then I would say you probably want to stick to the order for a little while, and because trust is probably a little dicey for a while. And so reestablishing that trust, where now your ex is just your co-parent, and then trying to find that common ground as only that, and
Yeah.
still communicating, because we know what happens when the parents don't talk.
Yeah.
And it's not good, by the way. So I think that re-earning that trust by working the order, and then being flexible and cordial with each other. Because honestly, those are the things that bring people back to court 2 or 3 years later, is when those
I was
things
going to say, is
break
that
down.
pretty common that like after a divorce happens, people have to go and rewrite?
Yeah, sure. Well, and it's
or just revisit
it
certain
has to
things?
well, yeah. I mean, there are those technical things that are the battleground, right? But oftentimes it's really about the conflict between the exes, right?
Yeah.
It's their personality and their own issues about them, or maybe their own relationship, or how they broke up, and those things sort of fuel the ongoing conflict. And I will tell you that there's an old saying, which is, the more you go to court, the more you go to court. And it just it tends to self-perpetuate, and people tend to keep coming back. And I mean, I've had the same case 3 or 4 times, and I saw it when the kids were 2 or 3. I saw it when they were 7 or 8. I saw it when they were 12.
Okay.
Yeah.
That happens. I'm not advocating for that, but it happens.
But it's a reality.
I mean, you're not wrong. That's
for some people.
That's the situation that I'm in right now. I mean, I'm currently in litigation. So there's a lot of things that I cannot talk about. But same situation is, the divorce was finalized July, and by November so it was July 2024, and now November 2024, we're back in court, and it's still ongoing. And the divorce itself took 2 years. So it's kind of like you said, you can have those situations that are highly contentious. What is your suggestion for somebody who is in a highly contentious divorce? Meaning, sometimes you think, I was married to him for 20 years. Like, maybe I can see reason with this person. And like, what's your suggestion? Like, how do you see, like, it's very emotional, right, on my end. So how do you keep your client, like, You obviously, it's easier for you to take the emotion out of it. So what's your suggestion?
Sometimes, yeah.
So what's your suggestion for like, is it try emailing 1 or 2 times? Is it, you know what, let me do it? Is it situational? You know what I mean? Does that make any sense?
You mean when you say email 2 times, you mean
Like
you and
me,
your
like,
ex?
okay, you try to email him, see if you guys can work it out. If not, reach out to me. Or sometimes can you see the
I see.
writing on the wall and you're like, just disengage. Let me handle it with their lawyer.
Right. So you're talking about like, so there's an active case and it's, to what level should you engage with your ex when you're in the middle of a case? Is that, am I hearing you right?
Yeah.
Okay.
And my
Yeah,
situation is definitely a little bit different because I do have a protective order with me against him for me and my children. So it's very different. But hypothetically speaking, when you can see that this is a highly contentious situation, at what point do you recommend, like Melissa is still actively conversing with her ex-spouse, right? At what point are you like, you're not going to get anywhere, let's just go to court, or you're not going to get anywhere, let's go to mediation? Like, how much do you encourage people to spin the hamster wheel versus getting off, or, you know what I mean? Does any of that make sense?
I think so. So first of all, let me just say I'm terribly sorry to hear about the protective order because that means something really, really bad happened, and I'm really sorry to hear that.
Thank you.
And that's for you to apply for that means that you must have been fearful.
Yes.
And I'm very sorry to hear that. I wanted to say that first of all.
Thank you.
But secondly, I would say in a situation like that, there may be orders in the protective order about how you're actually allowed to even, or how he's allowed to engage with you, right? In your case. And so you certainly wouldn't want to initiate communication with him except in a court-approved way for fear of basically not you violating the order, but you either trying to tempt him to violate the order by you communicating with him, or maybe violating the spirit of the order because the other attorney might say, well, gosh, she must not be scared of him because here she is communicating with him, right? So I would say in your situation, and obviously you have an attorney, but I would suggest that you only communicate in some court-approved way, like one of these co-parenting portals, and I would keep it strictly to the health and safety and welfare of the children only.
Yeah.
So there's no conversation about your hopes and dreams and your dating life or your job or
you're just business partners.
Or him. Yeah, or him saying, "Hey, how's your brother doing? I haven't seen him in a while." That kind of conversation becomes less and less useful or helpful the more contentious that it is. Okay. Now, I will say there are people I've heard of, like Melissa, who remain friends with their exes, and some of them go on vacations together, and they have these on. Again, it's kind of a unicorn thing, but they that's how they live, and they co-parent that way, and it works for them. But I would say I would just trust your gut on that. I mean, if you have somebody that's has proven that they can't be trusted, or that is, using what you say, to hurt you or to undermine you with the children, perhaps, or with other people in your life, like your job or your family, perhaps, because people routinely try to go around the court process when they're losing, to get what they want some other way.
Okay.
So I would say, be cautious. And but I tell my clients, let's say that the divorce was just filed. Okay.
Yeah.
I will often tell them to, if they have children, to just talk about the kid stuff and nothing else.
Yeah.
And then if there is some negotiation that's happening, generally I would prefer to handle it just so they don't re-pick the scab every time they have the conversation. But it's also true. To be fair, there are people who are able to kind of negotiate things and say, "Hey, Gene, we've made this deal, and I want you to write it up." And I'll say, "Well, okay. What we need to talk about this and this and this that you guys didn't discuss."
Yeah.
But I get the overall thrust of what you're trying to do, and let's get it done. But I think it really depends on the level of conflict and the level of trust
Yeah.
or not that exists between the parties. And frankly, there's this other element that is present in a lot of ugly cases. And I hope you're not, dealing with that yourself, Rachel, but it's there's these third parties that have a stake in the case. Okay. It could be the kids themselves, like older children.
Mm-hmm.
It could be, your ex-in-laws. It could be their best friend. It could be their new girlfriend or new spouse or whatever. And these people may act as blockers and interfere with, you trying to get something done with your ex.
Yeah.
And so that happens a lot. And unfortunately, I'm sorry, this is a long answer, but unfortunately, because of the, I can have these cases like, Melissa's situation. I hope this doesn't happen, but where everything's rolling along okay. And then one of them gets married again.
That's why I looked at her and I was like, everything was great until my ex decided there was another person to make all those choices for us.
Right. And then what happens often in that scenario is that the whole dynamic gets thrown off because you're either in your situation, maybe now, excuse me, you're dealing with, you're seeing this other person at exchanges maybe, or you're maybe your ex kind of puts her on the phone. Hey, you talk to her,
or she puts herself on the phone.
Yeah.
I'm like, who are you? Why do you have a say in my family?
Right. And that even happens on these co-parenting portals. I have clients that swear up and down that it's not actually their ex who's on the portal. It's their new person.
Yeah. Well, that's how I'm like, I was married to you for 20 years. I know exactly what you sound like and the things you would say and not say. This is not you.
Right. Sure. And so, unfortunately, sometimes these really kind of pleasant post-divorce situations kind of take a left turn and go in the ditch because of the new person. And so, unfortunately, that fact pattern that you're describing is really common with men. Men will often, post-divorce, meet somebody else and, consciously or not, try to find somebody to sort of fill that role that you did. And it kind of creates this vacuum, let's say, and where the guy's not doing the parenting, and it's sort of a power vacuum, and maybe he's a weaker person, and then this woman comes on the scene, and she's going to be the new, stepmama bear, and that stepmother story is very common at the courthouse. Okay. Now there are also great stepmoms that, know kind of where their lane is and they stay in their lane. And, I don't see it as much on the other side where, the ex-wife meets some guy and then the guy wants to take over.
Yeah.
I'm sure that happens, but it's a lot less common.
Yeah. Makes sense
in my experience.
So I would say,
but I'm sure it happens.
Overall, then it seems to me like if I'm coming to Jean and I'm saying, okay, I need a lawyer, then you're kind of hand-holding me through the whole process of like, okay, he emailed me this. And it's okay for me to just send that correspondence to you and be like, help me with how to reply, or because even though, like you said, things always start off nice, you never know how they're going to go. And I feel like
sometimes.
Well, and it seems like almost you can get a better vibe of like, okay, it's time to disengage, or it seems like this is a non-aggressive email. You can say this.
Yes. And just like the experience you have, you probably can see writing on the wall,
That's
like, okay, this is going to happen. And that's where it would be so helpful to have someone advocating for you when you have no idea what you're doing. Cause I can look back and say, I wish I had someone on my team rather than me just trying to figure it out.
Well, but you also, I mean, in your defense, I mean, you were trying to show good faith and maybe put your children first, and the idea that it didn't have to be ugly. And I see a lot of women like you that really want their ex to have a great relationship with the children, and they want to still work with the person, and they approach it from a good faith perspective, and you have to live with yourself, and so I wouldn't second guess that. Okay. I mean, that was the right decision for you until it wasn't,
And that's the thing is we just need to also remind people that sometimes things change, and it's okay if you need to go a different route at some point. You don't have to stick with always being on your own or doing something. There might be a point where you need someone to help you.
Sure. Well, and it's common that there's some event that sort of like whatever the assumptions were at the time of the divorce, something in the future happens, and all kid related orders are subject to modification as long as they're under 18. Okay. So just because you get an order that makes sense when they're 3, that order might not make sense anymore when they're 10 or 12. And life has happened, right? I mean, in between, there's new spouses or significant others. There's new jobs. Sometimes people move or want to move. Sometimes there's a problem with the child that, maybe your 3-year-old unfortunately has some developmental issue that doesn't even, pop up until after the case is over with. And that changes, the roles that everybody's playing and what needs to be done. So, the law says that, you can come back to court theoretically after a year following a final order. If you file a case before the year, you have to basically show that there's some imminent harm happening, which is what it sounds like happened in Raechal's case. Like there was some type of imminent harm that gave rise to the protective order, right? I'm speculating, but I'm assuming. And so, but ordinarily though, even in a non emergency type situation, people can, file a modification a year afterwards if there's been a significant change in circumstances. It's called a material and substantial change is the legal jargon.
This is perfect because I feel like there's going to be so many people listening to our podcast that are at the start of a divorce, but a lot of them will be like, hey, I did this and now it's time I revisit it.
Sure.
I think.
Well, and frankly, there's a lot. I'm sorry.
No,
go
keep
ahead.
going.
Well, I was just going to say a lot of what I do also, and all my colleagues do, is try to draft the order in a way where we're anticipating some of those future things. Now, obviously, we don't have a crystal ball and we don't know what's going to happen, but we like to have some built-in things that might keep you from coming back to court, like that co-parenting portal. Or some people in a more disputed case, Raechal, I mean, there's these outside neutrals that can be appointed that are called parent facilitators or parent coordinators or counselors. And these are people that are there to help parents make co-parenting decisions because if they can't seem to do it on their own.
I can already see that we're going to have you back for a whole co-parenting one because I'm like, we're already 40 minutes into this and like, I want to get to where we're talking about.
I'm just getting warmed up.
I know.
I'm just getting warmed up.
Because like I have co-parenting questions, I have will questions, but I want to try to keep us on track in that the next thing we want to talk about is, okay, so we've talked about being the respondent. Let's talk about being the petitioner. And I want to talk about things like can you or can't you file for separation? Does it have to be filing just for divorce? Some states have cooling off periods. So let's give a general in Texas, like I'm thinking about filing. I come and I talk to Jean. What do I bring to you and what are the rules?
Okay, sure. So I think for the first meeting, it's whatever notes or calendar or journal, diary type stuff you might have. I would bring that just as a refresher so that you kind of bring up all the things that are going on. Yeah, I mean, I think if you have some working knowledge of your financials, that would be helpful.
Okay. What if I have no idea? Like, am I allowed to have passwords? Like, what do I do? Like, he pays all the bills. I don't even know if we're broke or in debt or what. What do I do?
Right. And that's going to inform the initial strategy, right? Which is that we need to file the case sooner than later. We need to get a temporary restraining order if we're in Tarrant County to keep him perhaps from doing things that you don't want him to do, like to move money around or whatever. And then we would probably need to do some kind of minimal to extensive discovery and ask to get the information so that you can know what you have. And that's a bit of a slippery slope because if you don't know, then how do you know when you got it? Or how do you know when you didn't get it? And so to use a Texas oil field, jargon, you don't want to dig a dry hole, right? You don't want to spend a bunch of money on a lawyer, trying to find something that maybe isn't there, right? And then you haven't accomplished anything. So that's a real judgment call. So what the divorce is doing is basically four things. Okay, it's unmarrying the couple, right? So we're unmarrying them, and it's easier to get married than it is to get divorced, right?
Yeah.
And the second thing we're doing is we're resolving the child issues. The third thing is we're dividing the property, and the fourth thing is if somebody wants a name change back to a previous name, they can do that. There's also some injunctions, like those are kind of permanent do's and don'ts. That maybe that's a fifth thing, but those are the things that we're like doing in the divorce. Okay. So what the attorney wants to know is sort of, well, what do you want? You know, what's your goal? And so I think having thought about that and kind of what you want is a huge part of the conversation, and the attorney can tell you if that's,
Realistic.
achievable or not. So the case is started, like I said, by filing a petition for divorce, and it's a lawsuit, and I pay a filing fee for my client. I get a retainer from them. I have them sign a contract. I use a client portal for my clients, like a lot of doctors and banks.
Yeah.
Everybody's got a portal, right?
Okay.
I have one too, and so then on that portal, my client's going to be communicating with me with messages, uploading and downloading documents. There's a calendar. All the billing is on there, so it's kind of a one-stop shop.
Oh, nice.
For me and my clients. And I would say most lawyers are using something like this now. There's some old timers that don't, but for the most part, we're all doing something like that. Okay. And so, I'm gathering information about how I can draft the petition and to make sure that I'm asking for what it is that you want. Okay. And we can talk about what that looks like. Now, the other person, the respondent, is entitled to have legal notice that they've been sued for divorce, right?
Okay.
I mean, you have to tell them, right? And so there's two ways that happens. One is, and this might have happened in Melissa's situation, where you asked him to sign a waiver of service. Okay, so he took the waiver in front of a notary and he signed it, and then you filed that back with the court. So, and that's him saying, I've received the petition. I know that about the case. I'm waiving my right to be formally served, and I want to have notice of anything that happens in the case. Right. Basically, is what that says. And and when somebody's willing to sign a waiver, from my perspective, that's a good sign, because it means that we're probably going to have an agreement. When they won't sign the waiver, or the person, there's some disputed issue about the kids or about the money, like Raechal was hinting at, I'm probably not going that direction at all in the beginning. I'm probably going straight to serving them and setting a hearing and getting a TRO, and I'm pushing the action, right? So serving them is what they're served with, as we talked about at the beginning, is the citation, which is the notice that, hey, you've been served, and then under that is the decree, and that's what they get along with the TRO. And basically, the divorce can't be final. The soonest it can be done is after a 60-day waiting period. So that's sort of our cooling off period. So we don't have a drive-through divorce here like in Nevada, let's say. Okay, you have that minimum waiting period. The only exception is for cases of family violence, and everybody else has to wait. And every now and then I'll have somebody that files and thinks better of it, and
well, that's what I was going to ask you. Is it because like Texas hopes you're going to change your mind? Like, what's the purpose of cooling off?
Yeah, it's basically that. It's to encourage people to stay together. And I've heard of other states. I want to say North Carolina has like a 6-month waiting period.
6 months.
Seems a bit much to
I
me.
can't imagine.
I had a friend tell me that.
But it's, it varies from state to state. So theoretically, the soonest the case could be done, if everybody agreed on everything, would be 61 days after the case was filed, and at least 10 days after the person has been served or signed the waiver. So they've had enough notice of the case, and it's not just, they're not getting served on day 59 and then they get divorced
and
on day 61.
Just for people that think, oh, okay, well, it will be done in 60 days. It's not. It could go on way longer than the 60 days. It just, you can't actually finish it. So I feel like some people think
the soonest.
Like, minimum. Oh, okay, well, I have 60 days. I'll be divorced in 60 days. No. I was under that impression at the beginning. I was like, oh yeah, this is going to be easy. 60 days. No big deal.
No, that's the floor, not the ceiling, So that's from the petitioner's standpoint, it's about getting the case going and sort of they're the ones pushing the action. They're the ones who are wanting to get to the end. And, there's only really basically three ways the case can end if you think about it, because it's a lawsuit, right? Either you dismiss the case and get back together, or you settle the case and there's an agreement, or you have a trial and the judge decides what happens. Those are the only three ways out of the case.
Yeah.
Okay. And so a lot of people kind of assume that, they'll sort of get what they want in the settlement process, and maybe not. Maybe they have to go all the way to trial to get a reasonable outcome.
How often do you see that?
Not often, but it's increasing. I will say that people are less agreeable now than they were 5 or 10 years ago, even. Like mediation is a court-ordered settlement conference where you're ordered to go try.
I was going to ask you to talk about that. A lot of people don't know that about Texas, that you have to mediate before you go to court. It's legally required, right?
Yeah, I would say in every court I practice in, the courts require it. Now, it's not in the Texas Family Code or in the Constitution, but it's a court practice that they basically won't set a trial for you.
Yeah.
Unless you've been ordered to go to mediation first. And you don't have to agree, but you're ordered to try.
If you can't figure it out, then we'll figure it out for you. But you got to go first.
Yeah. And I would say mediation is 70 to 90% effective on the day of mediation. And a lot of cases that don't settle at mediation do end up settling after that, before trial. But
go home and think about it.
And you do mediation, right? Like you do just mediation. If I'm like, okay, I want to file, but I'm right in between my case and Melissa's case. Can we hire you to mediate the divorce for us?
Sure. And, you want somebody, again, that is local and knows the courts and is an experienced family attorney, because they're going to know what questions to ask. And now the mediator is in a completely different role than the attorney, right? So the mediator is not an attorney for the parties. The mediator is simply there to encourage settlement and then to write up the terms of the agreement, which is not in the form of the final order, but more of like a list of the terms, right? Yeah. Like a bullet point list. Okay. And so the mediator is going to go in the one room where, one spouse is and, work on that, try to settle it, and then go back to the other room. And so it's a shuttle diplomacy where most of our mediations are not done in a joint session where people are, haggling over a table. It's the people are in separate rooms. Now, I have done those types before, but I think they're only effective for certain people. And I would say that's very unusual these days.
Yeah. You're probably going to lead into, you started to say you asked the question, and I did ask the question about, can you file for separation and not file for divorce?
That's it.
I knew there was
another question. Yeah. So in Texas, we don't have a concept of legal separation. You're either married or you're not. And that's important from a community property perspective because, which I'll explain here in a minute, but there's no concept of separation or legal separation in Texas. Yeah. Okay. So for example, I'll have people that have not been living together and they've been separated for 10 or 20 years, and the other person may be in another country, and now they want to remarry, or they're just ready to move on for whatever reason, and they have to do divorce, and they say, well, we were separated 20 years ago, and I'm like, well, yeah, but you're still married,
Married, yeah.
So community property is, and I don't know how much time we have, but I think this is important.
Yeah, this is very important.
Okay, so community property is a concept that came to America by way of the Spanish possessions in the New World. Okay, so community property is common to like Mexico and in most of the former Spanish possessions, basically the western part of the country, right? California and Arizona and Texas and many states in the western part of the country, including Texas, have a community property scheme. And what it means is that we think in terms of an estate, right? Yeah. So when somebody dies, you say, well, we're going to administer their estate, right? Yeah. So the estate is the bundle of property that existed for the deceased person, right? That also applies in the case of married people. So before you get married, you each have a separate estate, which consists of all the property that you owned before you got married.
Yeah.
Okay. Your separate estate also consists of any property that you get during the marriage by a gift or by an inheritance. So if your wedding band or any gifts of whatever that you received from your spouse during the marriage, that's a gift. It's your separate property, and it's not divisible in the marriage. It's in the divorce rather.
Okay.
It's a separate asset. Okay. So everything else that's acquired during the marriage from any source is community, and community assets are what the judge is dividing. So sometimes I'll have a case where the marriage is short and there's just not really much of an estate to divide, right? They just haven't had enough time to really accumulate much, or maybe they had hard times and that financial problems caused the divorce, and maybe they just don't have anything to divide, but the longer the marriage is, there's often very complicated questions about, is this asset separate or community? And did they have it before the marriage, but then something happened to it to maybe make it community, or maybe the community money was spent to help improve the separate asset. Like let's say you had a rental property before you got married, but then you take community income during the marriage
fix it up and
you build a pool in the rental property, right? So what happens with that? So there's so if you think in terms of estates or buckets of assets, so there's the separate bucket for, spouse one, a separate bucket for spouse two, and then a community bucket that is all the stuff that they got during their marriage. And it's all their income pretty much from any source, even separate property. So the rental income during the marriage from that separate rental house is community property if it's received during the marriage. So there's a lot of things like that we have to cover the ground on when we have a divorce involving, some level of property. And for most people, it's, there's in our area, there's probably a house, probably some retirement, maybe there's some bank accounts or some life insurance, some cars, and some valuable.
This is something that someone wants to bring to their first consultation. You want to know what's this bucket and this bucket and this bucket also, along with the financials.
I'd like to know kind of a ballpark of what the aggregate value of the estate is roughly, not because I'm, counting my money, but because I want to know, like, is there enough in the estate to justify the work that might be necessary, right? I mean, if somebody has a $50,000 estate, I don't want to be doing, $20,000 worth of work for them. Right. That's not a good use of their estate. On the other hand, if somebody has, a 7 or 8 figure estate, then spending the money on the attorney is probably very justified to make sure that you get it right.
And that kind of plays into all of this type of stuff. Like if you have a lot to split, your divorce is probably going to take a lot longer to figure all those types of things out.
Well, it depends. I mean, honestly, the child issues are often more contentious than the property ones.
It's good to know.
But, I think people have different motivations, right? And, there are tendencies certainly. And I can observe that, a lot of my male clients or male opposing parties tend to value certain things. And my, female clients and female opposing parties tend to value other things. And, but sometimes that's what makes a deal happen. The guy wants his retirement. She wants the house. Okay, well, great. Maybe there's a deal there,
Well, like, I'll give you a good example. I paid $40,000 for a morality class because I traded I traded investments, stocks, and bonds. I traded the value, $40,000 value, for a morality clause, which.
And was that worth it to you?
At the time. And then, because of what I knew the situation of his home life was, and this part I think I can talk about now is, his significant other had a child who was a registered sex offender. Mm-hmm. And so for me to protect my children, it was worth it to have the morality clause. For him, I mean, I can only assume he was willing to do it for the $40,000.
Right, yeah.
So you kind of have to figure out what speaks to somebody. And it's not saying his way was bad and my way was good and my way was bad and his way was good. It's more that you have to figure out what speaks to that other person that's going to motivate them to get the deal done. It is a deal.
Yeah. And what your relative values are, right?
Yeah.
Like what's important to you and what's important to him. And I would guess that if that was done in mediation, that that your attorney and the mediator were trying to sort of test for what was a big enough carrot, right, to get him to agree to what it was that you wanted.
Yes.
And if that was important to you, and he put a number on it. I mean, it's a little crass, but I've had guys do it the other way too, where a guy wanted 50-50 child possession so strongly that he was willing to pay child support, even though he made the same amount of money as his wife. He was basically buying 50-50 possession by paying child support, which is, you could look at it in one sense and say, well, that's offensive. But you could also look at it and say, well, that's what got the deal done, Yeah. So as a practical matter, those sorts of things happen all the time. I had a client once who, she said, Gene, what do you think about this deal? Because she was kind of almost to the end of it, and she wanted to know what I thought of this arrangement that she'd made, right? And she had been like Melissa and, was working it out on her own mostly. And she was the breadwinner, and she made triple what he made. And when I looked at what he was getting more than half of the estate, and she was going to have the children more, but he wasn't going to pay her any child support at all. And I said, gosh, it sounds like, you're really getting taken to the cleaners here, Yeah. And she said, well, Gene, I just can't spend another day married to this guy. I have to be divorced from him.
Yeah.
And so for her, it was, getting it done and
having it over with,
having her life back and having that resolution a year sooner than it would have been otherwise. Yeah. That had a value to her. And she said, Gene, I can make the money back, because she was the breadwinner.
Yeah.
She worked for a big company, and
she wanted her life back.
And so that, and there are, if you're in the position where you have that sort of capital to spend to buy that resolution, that may be worth it to you. But not everybody has that in their hip pocket to play that card,
Yeah. So I think, because we're about out of time, but I had two questions that I think are pretty important for when you're just starting here. Is one, in the state of Texas, and maybe you could speak to, we are on a national platform, but so we've focused a lot on Texas, and I would say the number one thing in all of this is to take the generalities that Gene has given all of you guys, and then find out specifically and this was something I didn't know. Each county is different. Each state is different. So those things are...
Each judge is different.
Each judge is different.
And that's what would be valuable is each judge. So.
Yeah. But is it better to be the respondent, the petitioner? Like, does it matter? Question number one.
Yeah, so I would say if you're wanting to be divorced and you've concluded that that's the only way to make it happen, then I would say I would prefer to be the petitioner, and I would prefer to be the party taking action.
Okay.
Because and oftentimes emotionally, the filing person is further along than the responding person emotionally, right? The petitioner's already made up their mind. It's over. It's not going to get better. I can't make this work anymore, or I'm going crazy. I can't deal with this anymore. I have to do this, right? I don't want to, but I have to. That's how most people feel when they file. And so if you're in that position, you don't want to be in a passive role where you're sort of waiting for the other person to do something. You want relief. You want to be done. Okay. So if you're in that spot, then certainly being the petitioner is an advantage. The other one is in our county where there's a temporary restraining order mechanism. You don't want to be on the receiving end of that, right? If you're the respondent and you get one of those, that could position you really poorly. And especially if there's some extraordinary relief in that, where you can't see the kids until the hearing, or you can't come back to the house until the hearing, or, if, to use Rachel's example, if somebody files and gets what's called an ex parte protective order, which is like it's like the TRO of protective orders. It's like a temporary little protective order until you get to the hearing.
Yeah.
Okay. You don't want to be on the receiving end of that, so there's a benefit to being the filer. Okay. In that sense. Now, I will say, if you're not sure you want to be divorced, or you think that there's a possibility of reconciliation, then I would not file. I would avail myself of your support system and your counselor, and try to make it work. But by the time people talk to me, they're kind of past that point.
Yeah.
Usually that's already happened, and they're not really positioned to have that conversation anymore. But it's surprising the variety of states of relationships that I'll see. Like, sometimes people will be really good about certain things in their relationship, but there's the one thing that is just awful, and that's what starts the divorce.
Yeah.
And sometimes it's the obvious things, like there's a cheating or a lack of intimacy, or there's been financial improprieties, or things like that. But I had a case recently that they had a wonderful relationship. They co-parented their 2 children beautifully. They adopted and had this beautiful family. They were well known in the community. And if you look at them on the surface, you would say everything's great. Neighbors, their block parties, everything. It's the suburban dream, right? And you would never know. But they had a business that they were both involved in, that they could not agree on how to operate this business. And it got between them. These people were still intimate with each other. They were still going to all the, the school stuff and the activities for the kids. They were still, having sleepovers for the kids' friends. And I mean, they were still doing the whole thing. Okay. And they were still close, like personally, but they could not get past this business deal, and it ended up breaking them up, which is sad. So to answer your question, those people tried longer to not file the case than somebody who had one of the more sort of obvious, I mean, I had a guy call me the other day and said, Gene, the cliche just happened to me. I come home and I find another guy in my wife's master bedroom closet. Talk about the cliche. I mean, I got war stories.
I was going to say, you probably
that's a confession episode.
But that stuff, there's those obvious things like, okay, he needs a divorce. It's over, right? But it's not always that clear. And sometimes people, want to try. And, no reputable attorney is trying to divorce people that, should be married.
That's perfect.
Or want to be married.
So if someone came to you and you thought, hey, this is probably something that, like, I want you to be 100% sure this is where you want, you could say, maybe go home and think about it for a minute. Maybe you don't have that. We've talked about before in our podcast is that everyone kind of hits a moment where, like, all of a sudden you just know. You've thought about it, and then you hit a point. You probably see people come in that haven't hit that point yet, but maybe just want some more information.
Yeah, I think that's not as common as you might think, but I would say maybe 5 or 10% of the people that call me are in the scoping it out stage, or the pre-divorce planning. But that's not as common. Most people are seeing me after it's in their mind anyway. It's done, or they've been served, and hey, I got served. Okay, and once, as the respondent, to answer your question, Rachel, if you've been served, that's kind of the bucket of cold water, like, oh, I guess my marriage is over, because they just served me with a divorce. And now you're playing emotional catch up, and where the other person is like way down the road and ready to move on maybe, and has somebody waiting in the wings maybe. And meanwhile, the respondent is like way behind, like, whoa, wait a minute. And then all the stages of grief that I'm sure you guys either have talked about or will talk about, with their they're in denial, or they're negotiating about it, or they're angry about it, and they're not in an accepted state about it, like the person who filed, right?
Yeah.
And so they're way behind, and there's this dissonance that then creates conflict between them, whereas the filer wants to disengage and move on. The respondent sometimes is like leaning forward, like, well, wait a minute, can we talk? I mean, what's happening here? And,
I feel like we just need to have lunch with Gene. Gene knows our lives way better than we know. I mean,
apparently we're cliche. I think that's what I'm learning. We're stereotypically cliche.
No, but exactly.
Humans are creatures of habit and pattern, and at least within our culture, our behaviors are I don't want to say predictable, but there's a range of of common responses, and unfortunately we can't seem to get out of our own way, and we end up in this situation, but you can't go back and change the fork in the road moment that happened 3, 4, or 10 years ago or whatever. And now your kids are along for the ride, and you just have to make the best of it.
Yep, that's exactly it.
Well, I definitely think we've decided we need to have you back on. And we do have what we call Uncharted Confessions, and that's where we go a little bit deeper. Sometimes it's just the questions that maybe aren't for everyone, but are for that person for a specific situation. So, but we'd love to have you back on to talk about child custody. We didn't even get to moving out of the marital home and how do you divide that.
I want to know more about this other segment. I mean, do I need like a beer or a cigarette for this other part? Or,
yes, that we have a different kind of a drink other than water for. And
I was just kind of feeling that out
it's
there.
It's where we talk about the things we don't want everyone to know. So it's our members only podcast. But I think we're getting into like these stories that you've got. I'm feeling like they're in Uncharted Confessions. We'll replace the names and talk about situations that you can get yourself into. I am almost that. I'm that anomaly divorce that you just don't see. And Melissa's pretty much like like you said, kind of that unicorn divorce where they just were able to work it out.
That's where I feel like we're good with this, is because we both had the exact opposite sides of divorce. Sure.
But for those of you that are listening or watching, you can find Gene's information on our website. So that's one thing that we provide to all of you guys is free resources. So we've got a link on our website directly to Sollow Family Law. And you can call. We have been emailing and chatting with his paralegal, Heather. So you guys can call and have a free consultation with Gene. If you are considering it, if you have just had the bucket of cold water dumped on you, call Gene and he can talk you guys through it so that you can decide this is the best step for me, or like Gene said, maybe I just need to not be pissed off that he dinged up my car or locked me out of the house. So,
and if there's any questions you want us to ask next time we have Gene on,
please, you guys hit up our Facebook community, and you can email me or Melissa, DM us. Any questions that you guys have for Gene, let us know. We'll have him back next month so that we can get you guys taken care of. Gene, thank you so much for joining us today.
It's my pleasure.
We're definitely excited to have you back on, and we're very appreciative of you. So, guys, don't forget to like, subscribe, follow us, and we're so thankful that you guys are here with us today, and we can't wait to have Gene back again.
All right. Thank you.
Everyone.
Bye.
Thanks so much for tuning in. If you enjoyed today's episode, be sure to follow or subscribe so you never miss an update. Just a quick reminder, everything we share here reflects our personal experiences and opinions. We're not legal experts, therapists, or even financial advisors. We're just two people navigating life and sharing what we've learned along the way.